Welcome back. In a previous episode, we looked at the various damages claims which may be instituted under South African law. For ease of reference, the types of damages which may be claimed are contractual damages, delictual damages, statutory damages, and constitutional damages. Today, we will be drafting particulars of claim, wherein we will be claiming damages from the defendant arising from its breach of a contract, also known as contractual damages. If you would like to refresh your memory on contractual damages first, check out the episode which should be showing in the top right corner of this video. Before we start, please note that we will not be drafting the summons component of the combined summons, but rather only the particulars of claim. We have already drafted and discussed the summons in depth. For more information thereon, check out our earlier episodes. Let's get into it. Brief summary of facts giving rise to the plaintiff's claim. The plaintiff is a landlord who leased commercial property to the defendant in terms of a written agreement of lease. For the purpose of our particulars of claim, the most important terms of the lease agreement are as follows. The lease would be for a period of 1 year, commencing on 1 January 2021 and terminating on 31 December 2021, and the defendant would be responsible for the reinstatement of the premises and all costs associated therewith before vacating same on the termination date. The rest of the terms will be made up as we go along. During the subsistence of the lease, the defendant breached the agreement by failing to pay the rental and associated costs, such as utilities. As a result of the defendant's breach, the plaintiff elected to cancel the lease agreement on 1 November 2021. Despite the plaintiff's cancellation of the lease agreement, the defendant remained in occupation of the premises until 31 March 2022. The defendant did not reinstate the premises, and as a result, the plaintiff had to do so at its own expense. The defendant has since settled the arrear rental and associated costs due to the plaintiff in terms of the lease agreement. The plaintiff now wants to claim damages. Can you tell me why the plaintiff would be entitled to damages? Well done if you got it right, but to answer the question, the plaintiff suffered the following damages: costs for the reinstatement of the premises, and damages as a result of the defendant's holding over of the premises after the plaintiff cancelled the lease agreement. This is known as holding over damages. Let's give the particulars of claim a bash. The heading, party, citation, and jurisdiction. As always, we will insert the heading particulars of claim. We will then insert a subheading titled the parties. We will proceed to first cite the plaintiff and then the defendant. Let's stick to the parties we used in a previous episode. Paragraph 1 will therefore state, the plaintiff is ABC Pty Limited, registration number whatever, a company duly registered and incorporated in terms of the company laws of the Republic of South Africa, with its registered address and principal place of business at 40 Hound Street, Rampart Ridge, Johannesburg 2198. Paragraph 2, which is the defendant's citation, will state, the defendant is XYZ Pty Limited, registration number whatever, a company duly registered and incorporated in terms of the company laws of the Republic of South Africa, whose full and further particulars are to the plaintiff unknown, with its chosen domicilium sitandi et executandi at 89 Walker Street, Sandton, Johannesburg 2164, and registered address and principal place of business situated at 14 Cadaver Road, Randburg, Johannesburg 2167. Before paragraph 3, insert the subheading jurisdiction. Let's pretend the defendant's registered address and principal place of business fall within the jurisdiction of the court. Therefore, we will state at paragraph 3, the above honourable court has jurisdiction to hear this matter as the defendant's registered address and principal place of business are located within the court's jurisdiction. The lease agreement. After the paragraph on jurisdiction, insert another subheading titled the lease agreement. Underneath the heading, we will start at paragraph 4. As you will remember from our previous episodes, under this heading, we will set out the circumstances surrounding the conclusion of the lease agreement in line with Rule 18, subsection 6. We will then set out the salient and material terms thereof. Rule 18, subsection 6 requires a party relying on a written contract or agreement to set out the following in its particulars of claim: that a written agreement was entered into between the parties, the type and nature of the agreement, the date on which the agreement was entered into, the place at which the agreement was entered into, the identity of the persons acting on behalf of the parties. In light of the above, paragraph 4 will read as follows. Remember that the facts are being made up as we go along. On or about 1 December 2020 and at Rampart Ridge, the plaintiff, represented by Simon Goku, duly authorized, and the defendant, represented by Bill Burr, the sole director of the defendant, concluded a written agreement of lease, the lease agreement. A copy of the lease agreement is annexed hereto marked A, and the contents must be read as if specifically incorporated herein. Now that we have complied with Rule 18, subsection 6, we need to set out the salient and material terms of the agreement itself. Remember, only set out the terms pertinent to the claim. At paragraph 5, we will state that the salient and material terms of the lease agreement are inter alia, and then we will proceed to set out said terms from subparagraph 5.1 onwards. Based on the above set of facts, we will need to set out the terms pertaining to the following: the nature and purpose of the lease agreement, the duration of the lease agreement, the rental associated costs and payment terms, the obligations of the plaintiff arising from the lease agreement, domicilia of the parties, and breach and cancellation of the lease agreements. I will keep the terms simple so that we can rather focus on the damages components of our claim. Starting at subparagraph 5.1, we will set out the terms pertaining to the nature and purpose of the lease agreement. Said terms are as follows. The plaintiff would let the premises, known as Unit 1 Santon City, Santon Drive, Johannesburg, 2178, the premises, to the defendant. Next up, we need to indicate the duration of the lease agreement. The defendant would lease the premises for a period of 1 year, the lease period, commencing on 1 January 2021, the commencement date, and terminating on 31 December 2021, the termination date. In the next few paragraphs, we will discuss the rental, associated costs, and payment terms. Just a reminder that all the terms we cite will be mentioned in the lease agreement itself. The basic monthly rental payable by the defendant to the plaintiff for the duration of the lease period shall be in an amount of 50,000 Rand, including VAT. The defendant's administrative costs shall be from the commencement date to the termination date, an amount of 1,725 Rand, including VAT. The defendant shall pay to the plaintiff a deposit, alternatively a guarantee, in the amount of 80,000 Rand. The defendant shall pay a monthly marketing fund contribution in an amount equal to 5% of the gross rental payable from time to time. The defendant's proportionate share of municipal charges, such proportionate share calculated on the same ratio that the floor area of the premises bears to the total rentable floor area of the building from time to time, shall be 0.60%. The defendant's estimated liability for his proportionate share of municipal charges shall be from commencement date a monthly amount of 2,500 Rand plus VAT. The defendant shall make all payments in terms of the lease agreement without demand, free of exchange, and without deductions or settle for any reason whatsoever, monthly in advance on or before the first day of each month. The plaintiff shall be entitled in its sole discretion to appropriate any amounts received from the defendant towards the payment of any cause, debt, or amounts owing by the defendant to the plaintiff in terms of the lease agreement. At the termination date, alternatively at any prior termination of the lease agreement, the defendant shall at its sole expense reinstate and restore the premises to the condition as it existed at the commencement date, ordinary wear and tear and damage by casualty excepted, without prejudice to any of the other rights of the plaintiff. From due date to date of payment, the defendant shall pay interest at the rate of 2% and per month during the period while the payment is outstanding on all amounts, rental and charges or otherwise, due by the defendant to the plaintiff in terms of or arising out of the lease agreement. We have finished setting out the costs and payment terms, so now we need to briefly mention the obligations of the plaintiff as per the lease agreement. The plaintiff's obligations would include invoicing the defendant before the first day of each month during the lease period, and not unreasonably disturbing the defendant's occupation of the premises. Following the plaintiff's obligations, we need to indicate the domicilium of the defendant. The defendant chose its address specified in 2 above for service of documents and notices, domicilium secundii et executandi, for all purposes of the giving of any notice, the serving of any process, and for any other purpose arising from the lease agreement. Next up, we will cite the terms pertaining to breach and cancellation. Should the defendant, inter alia, fail to pay rental and charges or any other amounts owed to the plaintiff in terms of the lease agreement on due date, or breach any other term of the lease agreement and fail to remedy the breach within a period of 7 days after receipt of notice to that effect from the plaintiff, then the plaintiff may, without prejudice to its other rights and remedies against the defendant, cancel the lease agreement and resume possession of the premises. In the event of a breach as aforesaid, the plaintiff would be entitled to recover all legal costs incurred by it, including attorney and client charges, tracing fees, and such collection commission as the plaintiff is obliged to pay to its own attorneys from the defendant. The costs would include, but not be limited to, costs incurred as from the date that the plaintiff instructs its external attorneys for dispute resolution, debt collection, and/or lease agreement enforcement. Without prejudice to any of the other rights of the plaintiff, from due date to date of payment, the defendant shall pay interest at the rate of 2% per month during the period while the payment is outstanding on all amounts, rental charges or otherwise, due by the defendant to the plaintiff in terms of or arising out of the lease agreement, including any monies disbursed by the plaintiff on behalf of the defendant. The salient terms of the lease agreement, as set out in our particulars of claim, will look as follows. Plaintiff's obligations. Once we have set out the material terms of the lease agreement, we need to allege that the plaintiff complied with all its obligations in terms of and arising therefrom. In other words, we have finished citing the terms of the lease agreement, and it is now time to set out the facts giving rise to our claim. So after the final paragraph pertaining to the agreement terms, insert a new subheading titled Plaintiff's Obligations. All we need to do under this heading is to state what I've just said, namely that at all material times, the plaintiff complied with all its obligations in terms of and arising from the lease agreements. This paragraph and heading will look as follows. If you want, you can go into greater specifics about the actual obligations with which the plaintiff complied. For example, you could state that the plaintiff tendered occupation of the premises to the defendant from the commencement date and that it invoiced the defendant timeously every month. Breach of the lease agreement. We now need to briefly explain to the court what the defendant did or did not do which gave rise to the plaintiff's claim. In other words, how did the defendant breach the lease agreement? Pleading the breach will be a bit more complicated than usual, as the defendant breached the agreement, the plaintiff cancelled same, after which the defendant settled the arrears. The defendant then remained in occupation after cancellation and failed to reinstate the premises. So we have a lot to work with here. Let's begin by inserting the final subheading, namely breach of the lease agreement. Below this subheading, we will proceed to set out the breach in simple terms, but we must make sure to include everything that's important. We have already discussed how the defendant breached the agreement. Let's start with the first breach, which was the failure to make timely payments of the arrear rental and associated costs. Due to this breach, the plaintiff elected to cancel the lease agreement on 1 November 2021. The defendant breached the lease agreement by failing to pay the basic monthly rental and other charges payable in terms thereof, totaling R400,000 on due date. The statement of account reflecting the aforesaid amount is Annex Year 2 Mark B. The plaintiff demanded payment from the defendant on 12 October 2021 by way of a letter of demand, a copy of which is Annex Year 2 Mark C. Despite demand as aforesaid, the defendant failed and/or refused to remedy its breach, and as a result, the plaintiff elected to cancel the lease agreement by delivering a written notice of cancellation to the defendant on 1 November 2021. A copy of the cancellation notice is Annex Year 2 Mark D. The defendant subsequently settled the arrears, so we will state, subsequent to the cancellation of the lease agreement, the defendant settled the arrear rental and associated costs in full. Although the defendant settled the arrears, it further breached the lease agreement by failing to reinstate the premises. Further to the aforementioned, the defendant also breached an implied term of the lease agreement. Alternatively, it acted unlawfully and wrongfully by failing to vacate the premises after the lease agreement was cancelled. It is important to take note of how we are to plead the plaintiff's damages. See as follows. Notwithstanding the plaintiff's cancellation of the lease agreement as aforementioned, the defendant remained in occupation of the premises until 31 March 2022, at which time it vacated same without attending to the reinstatement thereof. As a result, the plaintiff attended to the reinstatement of the premises at its own expense. The defendant's failure to vacate and reinstate the premises was unlawful and wrongful, alternatively was in breach of the express or implied contractual obligations of the lease agreement. As a result of the defendant's occupation of the premises, which constitutes holding over, the plaintiff suffered the following damages. The plaintiff was precluded from reletting the premises from the period 1 December 2021 up to and including 31 March 2022, which is the holding over period, the plaintiff was deprived of its right of use and enjoyment of the premises during the holding over period, and the plaintiff was required to reinstate the premises at its own expense. I need to interject here quickly. You're probably wondering why we are not claiming holding over damages from 2 November 2021, being the first day of the defendant remaining in unlawful occupation of the premises. The reason for this is that rental was payable in advance before the first day of the month. Therefore, rental for November has already been paid. We cannot claim both rental and holding over damages simultaneously. Got it? Okay, great. Back to the particulars. The damages suffered by the plaintiff for the duration of the holding over period are made up as follows. The market rental value of the property, calculated at R50,000 per month in 2021 and 2022, being equal to the monthly rental payable in terms of the lease agreement. The defendant's ancillary charges for the duration of the holding over period in the amount of R60,000. The statement of accounts setting out the ancillary charges is annexed here to marked E, and the total amount of the reinstatement costs incurred by the plaintiff in the amount of R90,000, including VAT. Attached here to and marked as Annexure F is the tax invoice as provided by Mr. Reinstatement Pty Limited, confirming the costs incurred. Sorry guys, I need to jump in here again. When calculating holding over damages, you can either use the market-related rental or the actual rental payable in terms of the lease agreement. I usually state that the market-related rental is equal to the rental payable in terms of the lease agreement. Also note that a claim for holding over damages can be brought in delict or contract. Hence the reason why we plead that the defendant's holding over was unlawful and wrongful, which is delict, alternatively in breach of its contractual obligations, which is contract. Now, back to the particulars. The plaintiff's total damages, which are made up of holding over rental, ancillary charges, and reinstatement costs, totals an amount of R350,000. This amount is calculated as follows. Holding over rental from 1 December 2021 to 31 March 2022, R200,000. Ancillary charges from 1 December 2021 to 31 March 2022, R60,000. And reinstatement costs of R90,000. The defendant is therefore indebted to the plaintiff in the amount of R350,000, which amount is due, owing, and payable. In case you are wondering why we are proceeding out of the High Court when our claim is less than R400,000, remember that the High Court has concurrent jurisdiction with the Magistrates Court. Check out the episode on jurisdiction for more information in this regard. For purposes of our example, let's pretend that we previously sent a letter of demand to which we received no response. The next paragraph will therefore state, the plaintiff demanded payment from the defendant on 1 April 2022 by way of a letter of demand, a copy of which is annexed here to Mark G. Alternatively, the summons serves as written demand for payment. You will note that we have sent 2 letters of demand, one in respect of the arrear rental and another in respect of the damages. We have already pleaded that we cancelled the lease agreement, so we don't need to do it again. The lease agreement has remained cancelled since the date of cancellation. In fact, we do not need to do any more. We have set out our particulars adequately, and all that is left is our prayers. The paragraphs pertaining to breach look as follows. Prayers. Our prayers will be relatively straightforward here. We know that we are seeking payments of R350,000, so let's state that. Our first prayer will therefore be payments for the sum of R350,000. Is the plaintiff entitled to claim interest on the amount referred to in prayer 1, and if so, at what rate and from which date? Take note regarding the rate of interest payable. In respect of contractual damages, where parties agree to a particular interest rate, courts will give effect to the agreement between the parties. The rate agreed upon must, however, be in line with legislation. The courts will not grant interest at 100% per day just because it was agreed upon. Unless expressly agreed by the parties to a contract, interest will be payable calculated as simple interest and not as compound interest. Where no rate is agreed, the prescribed rate of interest will apply, which is the repo rate plus 3.5%. The repo rate often changes, so double check same before you insert your interest prayer. Regarding the date from which interest will run, parties are again free to agree when interest commences to run, and this will be given effect to by a court. In the absence of an agreement, the prescribed rate of interest acts as applicable. In terms of the Act, interest on unliquidated debts, which includes a claim for unliquidated damages, shall commence to run from the date on which payment of the debt is claimed by service on the debtor of a demand or a summons, whichever date is earlier, and the judgment debt, including costs, shall bear interest from the day on which such judgment debt is payable. In our example, the interest rate and date from which interest runs is expressly set out in the agreement as follows. Without prejudice to any of the other rights of the plaintiff, from due date to date of payment, the defendant shall pay interest at the rate of 2% and per month during the period while the payment is outstanding on all amounts, rental charges or otherwise, due by the defendant to the plaintiff in terms of or arising out of the lease agreement, including any monies disbursed by the plaintiff on behalf of the defendant. Our prayer for interest will therefore look as follows. Interest at the rate of 2% and per month from due date for payment to date of final payment. As is clear from prayer 2 above, we have indicated the rate of interest as well as the date from which interest is to run. You will know from our previous summons we did together that the next prayer will pertain to costs. We are obviously entitled to claim costs, but on which scale? The general rule regarding costs is that unless it has been otherwise agreed, or unless there are circumstances that warrant a punitive award of costs against the unsuccessful party, costs will be awarded on the party and party tariff or scale. In our case, the agreement states that, in the event of a breach as aforesaid, the plaintiff would be entitled to recover all legal costs incurred by it, including attorney and client charges, tracing fees, and such collection commission as the plaintiff is obliged to pay to its own attorneys from the defendant. The costs would include, but not be limited to, costs incurred as from the date that the plaintiff instructs its external attorneys for dispute resolution, debt collection, and or lease agreement enforcement. From the aforesaid term, it is clear that we should pray for costs on the attorney and client scale. Our prayer will therefore be just that, costs on the attorney and client scale. Our final prayer will simply be further and or alternative relief. Our prayers will look as follows. Signing off. Remember to look at Rule 18 subsection 1 when signing off in the High Court. In terms of this rule, the particulars of claim shall be signed by both an advocate and an attorney, or, in the case of an attorney who has the right of appearance in the superior courts, only by such attorney, or, if a party sues or defends personally, by that party. Remember, this rule only applies to High Court pleadings. Pleadings in the Magistrates' Court may be signed by an attorney regardless of whether they have rights of appearance in the superior courts. We will pretend that the attorney in our example has right of appearance in the superior courts. The signing off portion of the particulars will therefore look as follows. Final steps. All that we have left to do is to compile the combined summons. This means that we must attach the particulars of claim to the summons and attach and mark the annexures to the particulars of claim. We obviously need to sign the summons and particulars of claim as well. Once the aforementioned has been attended to, you can make the necessary copies and draft the documents to accompany the summons for issuing. For more information on issuing, etc., check out our episode on the formalities of the summons. Thanks for tuning in, guys. The complete notes and draft of particulars of claim are available for download. Link in the description. You may have quite a few questions about this episode, so please leave a comment. I will respond to all of your questions. See you soon.